let's say instead of this trust not being correctly managed, it was correctly managed during your lifetime. Everything was done correctly, and then you died. So you had all your assets in this trust, and any asset that you couldn't put in the trust, like your 401k or your IRA, you knew enough to say, I'm going to put the correct beneficiary designation on those assets that are outside of the trust because they can pay on my death to whomever I want. You did all of that correctly. Fantastic. What's the problem? You've avoided probate. What commonly is done, because everything was set up and is operating like it should, is the person who is the next trustee. Now, let's say you were the first trustee and you died. Who's the next trustee? In your trust document, you will have named a successor trustee. And that successor trustee oftentimes doesn't know what to do. I mean, have you seen trusts? They can go from like 5 pages to 100 pages. And sometimes it's important to have a 100-page trust because there's all sorts of language that could come into play. That aside, my point is your successor trustee does not know what to do. Are they going to go see a lawyer? Maybe, maybe not. The reason I say that is because they don't have to go see a lawyer to help give them guidance because there isn't a probate. So they think they can do this all on their own. They can take a look at it and say, I think I know what I'm doing, but do they? That's a really big question. They are not, if they are not going to get any legal help, whether or not they're going to properly distribute out the trust now, if that's what you wanted, that's a great question. I don't know if they will or not. I can say that without legal counsel, there's a higher risk that they are going to do things not correctly, and that's not what you wanted. Your wishes, therefore, may not be carried out because the person that you nominated as a successor trustee simply doesn't know what they're doing. They're not trying to do anything wrong. They just don't know what they don't know. Let's talk about how this impacts a couple. And I'm not going to, at this point, talk about all the benefits of the will and why you might want a will and a probate. I'm still sticking with you've got a revocable living trust because you don't want to hassle with a probate, your family, on your death. And this couple properly did everything with a revocable living trust. By that, I mean everything is titled in it, it's been managed, everything's good on how this revocable living trust was set up and administered, and then one of the trustees dies. So typically when a couple sets up a revocable living trust, they're both grantors, they are both trustees, and they are both beneficiaries. And very typically, when one spouse dies, their share of the trust, let's say it's half, is set to pay to a new trust created within the revocable living trust. This new trust is an irrevocable trust. It will get its own tax ID number, and it is to hold all the assets which were the deceased spouse's share of this trust. The surviving spouse, let's say she is the survivor, the wife is, and she gets to keep all of her assets. But typically her assets are now going to form what's called the survivor's trust. She gets to keep using her own Social Security number for tax purposes. But this irrevocable trust, the decedent's trust, has its own tax ID number. Now, you might be thinking, this is getting complicated. If the couple simply has everything together in this trust, why would they now divide it on death until 2 separate trusts? Good question. You don't have to. If there's no reason to divide the trust, we wouldn't recommend you do it. But with a revocable living trust, oftentimes the reason for dividing those assets is, number one, to take advantage of the decedent's tax exclusion credit amount. I'll come back to that. And number two, to ensure that the deceased spouse, whomever they wanted to inherit from them, will inherit from them, because the surviving spouse might not be allowed to redirect the assets in the decedent's trust to anybody, that they can be used perhaps for her benefit, but on her death, they will go to the decedent's children, for example. Especially important when there's a blended family. So, tax reasons and to avoid unintentional disinheritance. Well, let's go back to what I said a little bit earlier about people don't get legal guidance, and especially if it's a married couple and you've already been serving as the trustee and now your spouse has died and everything's in the trust. Why are you going to go see the lawyer? You're not going to think about it. And even if you do think about it, you might say, oh, I'm going to save myself a dime here, so I'm not going to go see the lawyer. Okay. Well, what if that couple's estate was worth $4 million? And believe me, lots of people who have more than $1 million or $2 million are very frugal. How do you think they got more than $1 million or $2 million? They're very frugal. So they don't go see the lawyer. So instead of the proper post-death administration, which the lawyer should have helped the surviving spouse with, surviving spouse said, I don't want any help. I'm not going to go see the lawyer. So she ends up with having $4 million under her ownership, under her tax ID number, her social security number. What she should have done is went to the lawyer. The lawyer would have said, oh, let's put the decedent's $2 million into this decedent's trust. Will get its own tax ID number, and that preserves the decedent's credit exclusion amount. In Washington State, this is important. In Idaho, not so much. But in Washington State, our tax level, a state tax level, what can pass free of tax before Washington says they want money, is $2.193 million. So we want to make sure we take advantage of that $2.193 million. We would put, in this case, the deceased spouse's $2 million goes into this trust. And as a result, the surviving spouse, she has her own $2 million that she still has. But $2 million, the deceased spouse's share, is protected in this trust. When I say protected, it's protected in that the state of Washington will not tax that. It's also protected from creditors. So there are protections that come with it. It's also, if there wasn't a power of appointment given, that money in that trust also goes down to whomever the decedent wanted it to go to. So we're not going to get a disinheritance of anybody. That's how this trust is supposed to work. But when this surviving spouse doesn't get the help she needs after her spouse has died, she ends up with $4 million. $4 million is more than 2.193. On her death, there will be a Washington estate tax, and it will be in the hundreds of thousands of dollars, all because she did not get the help she needed. And I'm not blaming her or saying it was bad intention. It just happens. It happens so commonly and so frequently. That is one of the reasons that lawyers often recommend a will-based estate plan, because with a will-based estate plan, we're going to typically, the surviving spouse will come to the attorney and say, help, I need help. I don't know how to file all this stuff with the court. And the lawyer helps them. And the lawyer might charge $5,000 or $10,000 for the probate or whatever, but we will make sure that that surviving spouse doesn't pay hundreds of thousands of dollars in unnecessary Washington estate taxes. That's probably my biggest gripe about revocable living trusts, is people think, it's so easy, I've got it done. And they don't realize the consequences could be very, very expensive. That's a revocable living trust. And those are the problems with a revocable living trust. I'm not saying it's not a great planning tool. It is. You just have to realize that there's upfront work, there's management work, and there's work on the death of the first, or the trustee, or the trustor, and that work is often overlooked, and that ends up costing a lot of money.